She fought for what she believed in.
So,
Okay, and now
Jerry, if you were king for a day and you could change any U.S. Supreme Court case, you just pick one, and you could change it. What would you change? And your goal is to try to do the most good at reforming police, misconduct and excessive force and brutality, etc. Reforming the police, constitutional rights. Pick a case. What case would you pick and change?
Atwater.
Okay, tell me about Atwater for our viewers, and then tell me why.
Atwater versus City of Lago, Vista was a 2001 United States Supreme Court case that created the modern police state. In Atwater, there was a lady who was driving with her child in the back seat of a car. I think it was a fancy pants car, too. And I think she got pulled over by some local police officer 2 days in a row for, like, not having a seatbelt. And I don't remember if there was a problem with, like, a safety chair for Junior in the back seat. I don't remember. But it was something about violation of the Texas seatbelt statute. The maximum penalty for which is a $50 civil fine. So, under the Texas seatbelt statute, a judge can't put you into jail. And the most anybody could do to you is fine you $50. So that's it. So the question came before the Supreme Court as to whether or not the cop, having taken the lady to jail for a traffic infraction that a judge can't put you in jail for, was an unreasonable seizure under the Fourth Amendment to the Constitution. And the answer from Justice Souter, who I thought had better judgment than that, but I guess I was mistaken.
I've never thought Souter has good judgment, but go on.
Well, Souter was a bachelor from New Hampshire who was the roommate of an Orange County judge named Mike Beecher at Harvard. And it was appointed by a pretty moderate to liberal Republican, George H.W. Bush. But anyway, this is what happened. Souter said, well, we don't want the cop to have to figure out whether or not this statute allows me to take him to jail, or we don't want to have to figure out whether this statute allows me to take him to jail. So we're just going to say that if you do anything, if a cop has probable cause, not if you did it, but if a cop has a strong suspicion that you did anything that the law proscribes, anything, parking ticket, seatbelt, 1 mile over the speed limit, your wheel hit the center line, even in a state like California where by statute in California you can't be taken to jail for an traffic infraction if you have sufficient ID for the officer. So they specifically, prior to all this medical marijuana and legalized marijuana, 11357 of the California Health and Safety Code for reefer says that if you have like less than 28 grams, which is an ounce, that they can't take you to the Huska for it. They can't take you to jail. They just give you a ticket. Like the maximum penalty for a first violation is $100.
That was so Schwarzenegger gave us that.
Yeah. So what happened? So what happened was it was 5 to 4. Justice O'Connor, who was Ronald Reagan's gift to Barry Goldwater from Arizona. That's what it was.
Okay, go on.
Well, that's what it was.
That's funny, but go on.
Said that you're crazy. You're going to turn this country into a police state, and she was right. Mm-hmm. So I have to turn down cases. I got to turn down cases where people are arrested for murder, manslaughter, assault with a deadly weapon, and massive drug cases, incarceration beyond belief, bail beyond belief because they had a bald tire, because They went 1 mile over the speed limit. That's what happens. And that's where we're at. I got to throw out 3/4 of the false arrest case that come to me, because if you're suspected of anything, and I mean anything, that the law prescribes, it doesn't offend the Fourth Amendment to hook you up and take you to jail. And the reason that's so important is, in a state like California, they have false arrest claims. You get a civil state false arrest claim against the cop, but there's no attorney's fees.
Right. Okay.
So,
Explain why that matters to our viewers.
Because nobody's going to look. If a cop takes you to jail, let's say the last false arrest case I got $40,000 compensatory damages for a trip to jail and a booking, and $50,000 in punies. 7 out of 8 wanted to get $500,000, but $50,000 punies.
Ooh, 7 out of 8 wanted to give $500,000.
In punies against
So
the cop.
close.
Yeah.
Wow.
Okay. Anyway, so that's what happened. So now we know that on to the state false arrest claim, we go to let's say we took that case without a federal claim, it's a false arrest claim, and I wouldn't take it. I would not try it. I wouldn't take it. I wouldn't sign you up. But under the federal one, I got $202,000 in attorney's fees awarded, so I'm going to take it. But if you think I'm going to do $202,000 worth of work with $12,000 of that being out-of-pocket expenses, or $20,000 for a $40,000, you don't get expert witness fees in state court or federal court as part of your costs of suit.
And how much do expert witness fees cost? Because our viewers don't know that.
Let's say they you're traumatized, so you got to bring in a psychologist. So it's like, $10,000 to get examined, and having, $12,000 to get them examined, and then probably another $5,000 to have your expert testify and get them ready to testify, and then another couple grand because they're going to take the deposition of your expert before trial, and then you're going to have to pay for the prepping for it.
And how much does it cost to pay a court reporter for a deposition?
Right now it's about $500 a pop.
And how many depositions do you take in a trial usually?
Well, it all depends on what kind of case it is. There's a million witnesses around,
So this adds up. And who's paying that? And who's paying? Who's footing the bill for this?
Okay, so on the $90,000 case we got, right?
Mm-hmm.
40 or 50. If there was no attorney fees, this is what happened. Let's say we had, say $10,000 a cost. It wasn't that much. So we had $10,000 costs. I get 40% of $90,000, $36,000. I get my $10,000 back. That's $46,000. That leaves the plaintiff with $44,000. But I did $202,000 worth of work.
Mm-hmm.
I'm not going to take your case. You're not going to be able to get a lawyer. I'm not going to do $202,000 worth of work for $36,000.
Jerry, your thumb, I think, is over the camera.
Oh,
there you go. Okay.
You understand? I'm not
yes.
going to do it.
I don't think that clients understand this, how expensive it is. Because I see in the YouTube comments all the time when they watch a video of excessive force, easy money, ka-ching, easy lawsuit for an attorney. Can you just dispel that myth that people have that it's easy to get these huge settlements? And
it's almost impossible. Look, as a general proposition, you don't get an appeal in a case on any of the issue until after there's a final judgment. You've gone through a trial, or it's dismissed on summary judgment or something like that.
And then that's when you can appeal.
That's when you can appeal.
So you have to wait.
You got to get a final judgment to all parties.
Right. So you have to wait. Mm-hmm.
Right. In a cop case, they are entitled to 2 interlocutory appeals before trial.
Can you explain what an interlocutory appeal is for people who don't know?
It's an appeal before trial as a matter of right.
So basically in the middle of the proceedings, you get to first appeal and have that adjudicated before you continue on.
Well, this is what happens. There's an issue. Look. There is no goddamn law. It's all bullshit. It's whatever they say it is.
Right.
That's all it ever was. If you read, this is what happens in the real world. So I told you about qualified immunity doesn't apply to entities because of Monell. Then when you try to prove Monell liabilities to make the entity pay for it, they ace you out of the box. In other words, you can't even do it. You can't do that either because what happened, you file a federal lawsuit, you claim that the actions of the officers were approximately caused by a policy, custom, usage, or practice of the municipal entity that was a proximate cause of the constitutional violation.
So say the city council had a policy, or a police department had a written policy you're talking about.
Or they just beat the shit out of everybody and they don't do anything about it and you can prove it. Okay?
All right.
Or jack everybody up. That's a customer practice. The problem is how do you plead that in a complaint? Well, what you do is you type it up, the custom policy practice for doing X, Y, and Z. There are two Supreme Court cases that came up, one called Twombly and one called Iqbal. And they have to do with the plausibility of what's prayed for in the case from the pleadings in the case.
Mm-hmm.
So if I'm suing somebody for an auto wreck, but it doesn't show where there was an actual collision, so it was going fast, the judge is going to throw it out. It doesn't matter what the pleadings don't support a claim. Or if I pleaded that my stepson was killed in front of me by a police officer, I could make something called, if it was my real son, I could make a Dillon claim. It's called Dillon versus Lago, negligent infliction of emotional distress to a bystander who's a close relative. So it's my real son I make claims. Stepson I can't make claims. So I plead it's my stepson, and I pleaded my complaint. The judges throw it out. Say, well, you can't plead it. Too bad. See you later. Blah blah blah. You never get to anywhere on discovery anything with the stepson because the judge tossed it from the beginning. In state court, it's called demur. In federal court, it's called 12B6 motion to dismiss from failure to state a claim. So what happened is that because of these Iqbal and Twombly cases, the whole goddamn federal judiciary, from the district court level, thinks that you have to basically prove your Monell case. You have to prove they have a policy and all that in the goddamn complaint.
So the complaint is the first thing you turn in.
Yes.
Okay. And you don't have discovery yet.
You don't have anything.
You don't have anything yet. So
No,
you have.
but here's the thing. Rule 8 of the Federal Civil Procedure says that from a pleading standpoint, all the allegations of the plaintiff's in the complaint are presumed true
to
for
be
an eventual
true.
motion to dismiss.
Right.
Just look at demur.
Right. That's the standard. Is that they
Right.
presume
But
that the facts
they just
asserted are
ignore
true.
it. They just ignore it. And they dismiss your Monell claim, so now you're screwed on that. You can't even get discovery on it. You can't do anything on it. You're done. They just kick it out saying, well, you didn't plead enough facts to show that they have a policy or practice. So what do you mean? This is the complaint, pal. I didn't plead, come on.
Right.
But this is what they do. This doesn't matter. There's a case called Lee versus City of Los Angeles that says opposite, but they ignore it. The 2001 Ninth Circuit published case. They ignore it.
They ignore it. Okay.
If you plan on being successful in court, you've got to be the one that looks righteous and likable and polite and shut your goddamn mouth. And don't tell everybody you know your rights. And don't snivel when the cop does something that you know is stupid. Just be polite and humble. That's what you need to do.
Okay. So.
And if the cop tells you to do push-ups, do push-ups. Just shut your mouth and do push-ups. People will be sympathetic.
Okay.
Was a no woman in this life, short upon the earth now was her time. Of all the seeds she'd sown and the people she had known, deeply did she touch the soul of mine. She called a spade a spade. She stood on the edge of reason and even faced with death until her final dying breath. She fought for what she